All right, everybody, it is right at 11:30, and I hope everybody is ready to get started. This has been certainly an interesting week around our office or around our respective homes as it goes, and we hope to pass along some good information for you guys. My name is Todd Stanton. I hope, I imagine I've met most of you. We are glad to be a part of this. There is going to be tons of information to cover as we move forward on this. So we're going to have to move really fast. I need to put up a disclaimer at the beginning that this is obviously not legal advice, and there is an inordinate amount of uncertainty surrounding all of these things. So bear with us. We're going to give our best opinion on this. You're going to come out of this better informed than you were before. But even at the end of it, there's still going to be a lot of unanswered questions. I can't thank everybody that has been involved in putting this together. But I do need to give a special shout out to Jamie, our operations director, and Dave, our marketing lead, for putting all these logistics in place so quickly, and to our newest associate, Matt Toomey, for getting the information together. So we are not going to take questions today just because of the time. We're happy to take calls anytime and can easily set up appointments to get you guys the help that you need. And we'll be looking at another session for this next week, depending on the response from this and what happens in the next few days. So generally speaking, and this is not definitely not legal advice, but we're hoping to keep the perspective and expectations in check with respect to your response to this virus and how employers are reacting. I mean, we have to acknowledge that no one has any idea what's going on with this. Stuff is spreading very, very quickly for people, or from people to people who have no other exposure to the virus or no known. You don't have to be a gym licker out there or going around hugging and kissing to contract this virus, it appears. So we have no idea what's going to happen moving forward. And I think that we all have to expect that people, including our employees, are going to react with best intentions and goodwill, and we're going to have to be patient. Certainly, there's going to be exceptions, and we'll have to clean up that mess later. We don't think that you can focus on the 5% of your employees who are going to cause 95% of your problems generally, and all we can do is the best that we can with the information we have, and we're hoping to give you more of that information here today. So the agenda for today is going to be, we're going to cover the latest news. We're going to go over some general tips for how to respond to the virus. We're going to talk about the best practices from work for home, cover some frequently asked questions for the workplace, reminders about the Fair Labor Standards Act and OSHA, which are still going to apply. We're going to jump in and tell you what we know about the Family First Corona Response Act, Family First Corona Response Act, FICRA as we're going to call it, and then give you some practical points about the unemployment issues that we're seeing. So, like I said, we're going to have to move pretty quickly. So just last night, Senator McConnell expressed that he is ready to get a third relief bill going. That's going to focus on some support for small businesses, as well as these checks that we're hearing so much about. The other trend seems to be that bigger cities, San Francisco went down last night. Gavin Newsom in California tried to take California offline for all intents and purposes. Atlanta has basically ordered all public accommodations closed. Restaurants are still providing the drive-through. But this is the trend, and if you're public facing as it comes to this, you can expect to maybe get a knock on the door or an order, strong suggestion saying that it needs to wrap up pretty soon. We don't know when that's coming, but certainly it's developing day by day. Keep an eye on that news. We are publishing, so most of you probably know, we're publishing a daily digest that Matt is taking care of and sending out each morning with the news. We'll continue that starting again on Monday with the weekend's news. After this week around here, we need a day off. But in any event, I'm going to turn the microphone over now to Christine Green, counsel in our office, to talk a little bit about the general tips that we recommend that businesses and employers approach the coronavirus situation with. With that, I need to figure out how to share her screen. And I think that should.
Todd, can you hear me?
I can hear you, Christine. You ready to go?
I'm ready to go.
All right.
All right, good morning, everyone. Thanks, Todd, for that introduction. I'm going to go over general tips as well as best practices on working from home and the frequently asked questions. So jumping right in, as hard as it may be, don't panic, but we have to adjust expectations here. We can expect employees to get sick and absences to increase for a variety of reasons. And we're already seeing employer obligations changing, such as with the Families First Act that we'll talk about today. So it's important to stay informed on new developments and to start planning. We suggest creating a contingency plan for how your business is going to keep running to whatever degree possible, if and when a substantial portion of your employees are too sick to come in or have other coronavirus-related reasons. So part of this plan also needs to involve protecting your employees. That's where remote work, alternative work arrangements, social distancing, things like that come into play. You also want to maintain clear and frequent communication with your employees. So provide status updates when you have changes to hours, plans to stay open, plans to change schedules. Obviously, you want to tell them that you're sanitizing the office daily. And you also want to tell them what to do if they get sick, which we're going to get into that in a minute. So the more you communicate and check in, the more comfortable your employees are going to stay, and also the more cohesive your small business is going to maintain or be during this crisis. Hold on, let me see. Hey, Todd, I can't change slides. Will you do that for me? Okay. You can also expect your cash flow to take a hit if it hasn't already. We've got absences that are going to reduce productivity. We also have businesses being ordered to close. And then, as we're going to discuss, the Families First Act that's going to require you to pay sick leave and other paid leave for other coronavirus absences. So we're also not seeing a lot of government support for employers right now. We're only seeing reduced interest rates and deferred tax credits. So you got to make a plan to stay afloat. We don't know how long this is going to last. So you may want to consider taking advantage of the lower interest rates and getting that proactive credit line. You may also want to look into insurance coverage. I don't know what existing policies you have, but you may have business interruption coverage. Not sure if this is going to be covered, but it never hurts to ask. Call your broker. Don't just assume that you're stuck. You may also want to check in with your health insurance just to make sure that you're in good standing. You don't owe any premiums, because the last thing you want is a bunch of sick employees and then their health insurance isn't in place. So you want to consider cost-saving measures here, such as reducing hours for non-exempt employees. You may also want to reduce work weeks for your exempt personnel while also adjusting their salaries proportionately. How you reduce costs and stay open entirely depends on your business and your industry, but getting creative with this is certainly preferable to layoffs right now. All right, with working from home, you want to set clear expectations. I mean, the goal here is for your employees to stay healthy and productive. You want them to be able to continue to make money and also stay safe, keep their families safe. This is not a staycation. This is not for them to go work at Starbucks. They're supposed to stay at home and work and stay safe. Also, emphasize that productivity standards still apply here. They're expected to work as much as possible. Note that this is a temporary arrangement. And normally our advice on work from home arrangements is that work from home is not a substitute for childcare. But right now, the wisdom is just get what you can out of your employees, because the circumstances are different right now. All right, you can hit next, Todd. All right, and in preparing for working from home, normally we would spend a lot of time with setup and preparations. And even with that, you've got lots of issues that come with work from home. But so these are just general tips on how to prepare, how to issue spot and get things moving quickly. There are probably going to be some messes, some balls dropped, but generally we're going to try to keep the wheels on with these tips. Okay, so you want to test connectivity issues. Do your employees have appropriate hardware, software, VPN? Do you have an IT resource to help them when they've got issues? Are there collaboration tools in place? You also want to design flexible schedules. This is not going to be 100% 9 to 5 as usual. Shifts are probably going to have to be different, especially where childcare is concerned. And with that, you have to plan for hiccups and interruptions and be realistic about childcare, especially with young children. I mean, toddlers certainly make work more difficult. So looking at manager tasks, you want to delegate scheduling to managers and have them confirm with employees what schedules they're able to keep and get them to commit to it. You also want your managers to confirm with employees that they have a designated and private workspace set up for their work, other than their couch or bed, if that's possible. You want managers to outline expected tasks with clear deadlines and expected response times if the managers are trying to get in touch with an employee. It's also a good idea for the managers to be checking in with their employees at the beginning of the day and at the end of the day. And depending on your line of work, maybe even more than that. But you also have to keep in mind that this situation is ripe for burnout, stress, and breakdowns. I mean, I think everyone is already stressed. We've got changes to routine, family care burdens, the obvious concern about catching the virus, and then financial concerns about the economy. And this is a stressful time. So having your managers stay in frequent communication with your employees just so they can anticipate when someone's super stressed or getting close to a breakdown so they can like redistribute workloads. And then also stay in touch with your managers too. This is going to be stressful for them. Moving into frequently asked questions, I mean, the big one here is, what do you do if your employee is sick? If they've got a positive coronavirus test or diagnosis, or they have flu-like symptoms, a fever, or you suspect that they do. I mean, the first thing to do, you got to excuse that person from work and encourage them to go home and also get treatment and testing. Before they leave, though, also ask them for a list of coworkers with whom he or she has had close contact, like within 6 feet, in the past 14 days. And you probably want to excuse those coworkers as well until you've got a confirmed test that it's not coronavirus. Otherwise, they're going to have to stay out for 14 days. And if they don't have symptoms, then they can come back after those 14 days. You want to appoint a person for necessary reporting and documentation of this. I mean, the obvious choice is someone in HR. You also definitely want to disinfect the office or workspace, or because if you've had a sick employee in there, their germs are everywhere. So when can the sick employee come back? The CDC has issued some guidelines on that, so you may want to pull those up. But in essence, they're saying if an employee doesn't have a fever, the symptoms have improved, and they've had 2 negative tests within at least 24 hours apart, then they're cleared to come back to work. Also, don't publicize that sick employee's name. I mean, you're obviously going to have to disclose it somewhat with discussing with coworkers on the exposure level, but only disclose what's necessary, and just don't forget your duties to protect protected health information, and just avoid broadcasting, Todd's got coronavirus. So moving on to the next one.
I don't have coronavirus.
All right, good. So can you take an employee's temperature? We're getting that question a lot. The EEOC has issued guidelines saying that you can, but we do not advise doing it. I mean, number one, infected individuals are contagious before developing fevers. And some people who have coronavirus never get a fever. So it's not very effective anyway. Second, it's a temperature screening is a medical exam under the ADA. So It's just better to avoid that and ask employees to stay home if you have a fever or symptoms. Go see a doctor, go get tested. But but don't we don't recommend taking the temperature. And consider too that if you have a manager lining all the employees up taking temperature readings, you're exposing that manager to potentially sick individuals. So if you have a third party requiring a temperature test, we recommend getting a trained medical professional to take the temperature. So is it okay to inquire about the potential exposure? The best practice here is, rather than asking individual employees, is just to notify all staff that you're taking precautionary measures and you're prohibiting anyone with a fever, flu symptoms, or a positive coronavirus test, obviously, from coming into work. And you're also prohibiting anyone with exposure to someone who has a confirmed coronavirus diagnosis or suspected diagnosis for within the last 14 days. And you want to instruct your staff to notify you if either of these apply to them. Can you require an employee to get tested? That depends. If testing is available, then yes. But I know we're hearing a lot of people are having trouble getting the test. So if they're not able to get a test, then it's not a good idea to require it. Okay, hit next, please. All right, so what if an employee objects to certain activities or work duties because of their fear of being exposed to coronavirus? Generally speaking, you can deny that objection, but there are some circumstances where you don't want to deny that. First, if you have a confirmed coronavirus diagnosis on staff or with a third party that can't be avoided, then yes, let that employee sit back. If the duty involves traveling to an area of high transmission like New York or Washington State, or going to a public gathering, then yes, that's a reasonable objection. Let them sit back. If the employee is sick for another reason or has a compromised immune system, then yes, let them sit back. But otherwise, you can deny those objections, especially if your business serves an industry that's critical to public health and safety. So what should you do about clients, vendors, or other third parties in the workspace? If your work is open to the public, your focus needs to be on sanitizing at least once a day and focus on protective personal equipment such as gloves and masks for your employees and giving them sanitation wipes, so Clorox wipes. If your office or workplace is more of a private facility or office space, you still want to focus on sanitation, but you also want to prohibit anyone with the fever or flu-like symptoms or obviously a positive coronavirus diagnosis. So what should you do if you have if you think that you have a false report by an employee? I mean, right now, unless you have clear proof that the employee is making it up, it's best to assume that the reports are true. And it's just the best interest for your employees, safety first here. If testing is available, it's okay to require them to go get tests and to send you the documentation of their results. And as Todd gets into the Families First Act, that's going to take effect, and you may run into discrimination and retaliation liability if you terminate or discipline an employee that you think is falsifying a coronavirus diagnosis or exposure. So unless you have clear proof, we just don't recommend doing that right now. That's all I got. Turning it over to Todd.
Thanks, Christine. I appreciate that. A couple things quick before we move on to the rest of this. The chat board is lighting up with speculation, rank speculation concerning many of my physical and mental health problems. And so let's keep this focused on coronavirus for now, rather than on what you guys think I might need to work on in my personal life next. It's good to know I have so many friends out there on attending. So the other thing that I want to say real quick is that Christine is one of the attorneys here in the office who is going to be available. We're setting it up to have for non-Stanton law clients the ability to make quick, very easy phone calls to us in half-hour increments. We'll provide some more information about that later. along with the contact information for the attorneys. Hopefully we're going to make that as easy as we can to get you guys the answers that you need while we still don't go bankrupt in the process. Of course, Stanton Law clients can still call their normal Stanton Law attorney and go through the normal channels, but we want to make it as available as we can. We understand this is a scary time. We want to keep those expenses as low and as reasonable as possible. So for those of you who I've talked with before, you know that the FLSA is my hobby horse. It is a big part of our practice, and the FLSA is not going away during this rather weird time. So we are still going to have to make the proper distinctions between exempt and non-exempt. And as it rolls into the FCRAs we're going to talk about, that becomes pretty important. Employees still have to be paid at least minimum wage for all hours worked, whether that is in the house or whether that's in the normal place of business. And they still have to receive overtime, 1.5 times their regular rate for hours worked in excess of 40, assuming that they are non-exempt from those overtime provisions. We'll talk a little bit more later on about how to calculate that regular rate that they're going to use to calculate what is owed under the sick time. That's going to become even more important now than it has been in the past, but that is certainly something we need to keep aware of. It is also even going to be even more important now that we keep an accurate record of the hours worked, both in and out of the office. If you have not been keeping your employees' hours, this is going to be a good chance to make sure that we can put those policies in place. Making sure that they're recording all hours that are worked is the only way to make sure that we're calculating the regular rate properly, therefore to figure out whether they're owed overtime, and then also whether or not or what their sick rate is going to be. All right. So it is important that we understand here that there's got to be flexibility for all involved, right? If you are having non-exempt employees work more than 40 hours in a week, you got to pay them time and a half that regular rate. It might be such that we have prohibited overtime in the past. It might be a good idea to go ahead and authorize them to work that extra time if they're able to do it. It might require after hours work, and you're perfectly allowed to go ahead and set those hours as you want. But if they work more than 40, you got to pay them that. You can always reduce your hours for non-exempt employees. If they're not a salaried employee, they're not exempt from overtime, you are welcome to reduce their hours and set those as you would. If you only want them working 15 hours a week, tell them you only want them working 15 hours a week. We'll talk about what that may do to the unemployment benefits here in a second. It is always okay to have folks do work outside their job description. If somebody tells you that's not my job, that's not my responsibility, you are more than entitled as an employer to say tough noogies. We got to have you all hands on deck in this situation. We'll get some cross training out of this and hopefully come out stronger at the end of it. But it's okay and to ask folks to do things outside their normal day-to-day duties. Volunteer workers are not okay. I got a call from a employer earlier this week who said that he was not going to be able to pay his employees, but that they wanted to keep coming to work to help him out and to keep him afloat. If workers are coming in and working, pay them at least minimum wage for the hours that are worked, and pay them time and a half minimum wage for the hours worked in excess of 40. We are not going to be able to abandon the Fair Labor Standards Act, which is generally frowns upon indentured servitude. It is going to be all right to make alternative arrangements. You can offer them additional PTO. If you want to pay them not to work, that's perfectly okay. We just have to pay them when they do. And keep in mind that for exempt employees, not just salaried employees, but exempt employees, we have to pay them their full weekly salary for any week in which they do any work. So the purpose of a salary is that their compensation is not reduced by the quantity or quality of their work. And so if they do any work during the week, they get their full salary for that week. If you're going to furlough an exempt employee, if you're going to ask them to take a week off, then that's fine. You don't have to pay them the week, their salary for that week, but it has to be an entire week off. If you make improper deductions from a salaried employee, we got another FLSA issue. Right? If you are going to change an employee's pay during this time, as long as it doesn't fall below the FLSA thresholds, that's perfectly appropriate. So for instance, if a salaried employee, you anticipate them only working 20 hours a week, moving forward, it is okay to reduce their salary in anticipation of the reduced work, but we don't, as a general rule, tie their salary to any particular hours that are worked. We want to make sure that the employees continue to understand that their salary is compensation for all hours worked. And if they think they're working too many hours for their salary, they can adjust it up or down. But adjusting the salary is fine. Don't tie it to hours. All right. More flexibility stuff. So we can require people to work from home, and we can encourage them to work from home. If they've got a job to do and they can't do it at the office, and you don't want them to do it at the office, it's perfectly appropriate to send them to the house and require them not to come into the office, but still maintain performance expectations as best you can. Remember that as we're sending folks home for work from home or allowing people to work from home, we've still got equal employment opportunity laws to look for. If you say, okay, all the moms can go on home and take care of their kids while they're out of school, but dads, we need you to stay at the office. We're looking at a disparate treatment claim, so make sure that we're not basing those sorts of perks, as it were, in the workplace on any protected characteristic. I would not recommend that you change the rate of pay for work from home hours. It's just going to make calculating overtime that much harder. And quite honestly, so many employers are screwing up the FLSA as it is. There's no reason to throw in different rates of work as we try to calculate the regular rate. Leave it as it is. This is going to be a big mess, and that's not what's going to bankrupt you. There's lots of other things that are going to be a big problem. We can't deduct the cost of tools, right? So if you're requiring them to buy a computer, just can't take them below minimum wage. Make sure that we've got a good timekeeping mechanism so that they are keeping an accurate record of the hours that are worked, including all of those after hours emails, including the checking voicemail. We need to make sure that they are head down and working. Certainly, there's going to be more distractions at home. The general rule under the Fair Labor Standards Act is that you cannot deduct from pay breaks less than 30 minutes. 15 minutes in this. If breaks are less than 15 minutes, you need to go ahead and pay them and hope that they are meeting their performance standards, and that's how you measure this. Don't use your wage payment as a disciplinary measure. Right? If you have employees who cannot work from home and don't want them in the office, probably a good practice to see if we can find some other things to do. One of our municipal employers was sending folks who couldn't come into the office out to do some maintenance around the property so they could social distance and still get some work done, still be productive, and still earn their paycheck rather than sitting at home. All right, so the OSHA standards still apply. I'm going to jump on this real quick. Personal protective equipment and respirator standards. As we've all probably heard, the normal surgical masks are not going to be very effective to these things. I was involved in one OSHA case not too long ago in which the employer did not provide masks, but allowed employees to wear their own masks into a portion of the facility where there were strong paint fumes. OSHA came in for another reason, saw the non-compliant, non-effective respirators and masks in the office, and issued a violation to that employer because they weren't fit properly. So unless you're in the healthcare or it's been, you've had a recommendation provided by a healthcare professional, we don't recommend providing your employees masks. Allowing them to work, to wear what they bring in is one thing, but we wouldn't recommend that you provide them. Remember that if there is a COVID diagnosis in your work and you have reason to believe that it was contracted at work, normal reporting requirements for OSHA still stand. So if it's a hospitalization, you have to report it to the Occupational Safety and Health Administration within 24 hours. And if somebody who's contracted the COVID virus at your place of business passes away, you have 8 hours to report that. That doesn't necessarily mean that there's going to be a citation or anything else, but we don't want to fail on those reporting requirements. All right, so this is probably the reason why most of you are here, and I appreciate the indulgence for the rest of that stuff. But as you're going to see, some of those topics fold into this and have to serve as the baseline of knowledge in order for us to get to where we're going. Recognize that the two pieces that are garnering at least the most attention in the employment law world are the Division E, the emergency paid sick leave, and the Division C, the emergency family and medical leave parts. But there are 6 other bubbles to this, 6 other buckets, divisions, whatever we want to call it, to this big act. If there's an interest, I'm sure you guys will let me know, and we can talk about some of these other things in our next seminar, but we're really just focused on those 2 divisions, E and C, and how they're going to affect employees. So I'm sure you guys have seen, if you haven't, this flow chart, which we're going to keep coming back to, really makes clear how these things are going to work to get these 2 divisions, C and E, the employee paid sick leave and the Emergency Family Medical Leave Act, are going to work hand in hand. And Minori in our office and Matt in our office put this together, and we've gotten great feedback about how this makes it much, much easier to understand. So the first question we're going to ask is, do you have between 1 and 499 employees? The answer is an unequivocal yes. If yes, then the unequivocal follow is that these provisions apply. We'll talk about the limited exceptions as we move through, but the general rule is you are now subject to these things. So the first one that we're going to talk about here is the Emergency Paid Sick Leave Act. It applies to all employees for leave stated that we're going to get to in a second, and provides 80 hours of paid leave for all of your employees. Don't jump up and down on the panic button yet. It's probably not as bad as it sounds, although it's certainly not going to be a vacation. The second part of it is the Emergency Family Medical Leave Act, Expansion Act. There, it used to be such that employees had to work for you for 1,250 hours or for in the past year and a year. That is now cut to 30 days. Essentially, all employees who've been with you, all employees who have been with you for 30 days, not just a year, are now entitled to the rather limited reasons that they can be out for paid leave after the sick leave expires. So the second part of this goes to the reasons for leave under the Sick Leave Act. There's 6 of them. We're going to go into the detail of that in a second. We're just using this to put it into context. And then the most important part, some of you may have heard that the law originally came out to last Sunday and gave me palpitations for the next 24 hours as I was wondering how I was going to comply with this, and much less how our clients were going to apply these laws. The amendments that were eventually signed in the law substantially narrowed this paid leave piece on to only this qualifying need as defined here, which means that after we get done with the sick leave, the only people who are going to get paid leave are people who are out because they have to care for a minor son or daughter and are unable to work or telework, and the absence is because of the COVID virus. So it's not as bad as it was, but it's getting there. So let's dive into the specific pieces here, and a lot of these questions that are popping up are gonna be answered, I hope. And then we're going to be sharing this presentation as well as the audio immediately following this. So, all right. All right, so again, Emergency Paid Sick Leave Act, all employees, and if you've got below 500, then you're subject to it. We get a lot of questions for what we call integrated employers, a particular business owner who's got several LLCs hanging around, and he wants to know whether he can aggregate all of those LLCs together to get above the 500 threshold, and therefore not have to pay these benefits. The answer is maybe. What is an integrated employer is a list of non-determinative factors, a non-exhaustive list of non-determinative factors that allow a lot of discretion. And when, in most instances, employers are trying to de-aggregate, they're trying to get it so that their separate subsidiaries, separate LLCs are not aggregated for different purposes. So if you think it's a good idea, you don't want to pay these benefits and you're trying to aggregate, recognize you might be stuck with that argument moving forward. That may complicate things for tax reasons or for other employment laws. Be careful what you wish for. And if you're going to try to aggregate, let's talk that through before we do. All right. So all employees are eligible for this. If you're 1 to 499, and they get paid sick leave if they cannot work for any of these 6 reasons that we're going to go into detail. Generally, 1 through 3 of these reasons relate to employees' health, and generally the 4 through 6 relate to the employee's care of another. All right. So reasons 1 through 3, they're subject to a quarantine or isolation order related to COVID. All right. So if this has not happened yet, that we're aware of, that there has not been a federal, state, or local quarantine or isolation order. So nobody should be able to get paid sick leave because of that, number 1. Number 2 is the important one. They've been advised by a healthcare provider to self-quarantine because of COVID, or they're experiencing symptoms of COVID, number 3, and seeking medical diagnosis. So this is not, I broke my arm and I need paid sick leave. This is not, I have cancer and I need sick leave. This is the only time that paid sick leave is going to be applicable is if it is COVID related. All right. That's a great question. Somebody just popped up with California does not qualify under number 1. I don't know the formalities of Governor Newsom's order about whether it was a pure quarantine or isolation order. I know that he's ordered things shut, but that's something that we can take offline. That's a good point. So when an employee qualifies for one of the sick leave under one of these 3 reasons, they must be paid their full regular rate for these 80 hours. Now that's capped at $511 a day. So you're looking at $5,100 per employee for the 80-hour leave that we're looking at here. What's important to me here is determining the regular rate. So two curious situations that we'll get to in a second. If they have an hourly rate, that's their regular rate. If they're a salaried employee, it gets a little more complicated. The salary's regular rate is calculated by dividing the total number of hours that are regularly worked into their compensation. And that number becomes their regular rate that's owed for these 80 hours. If it is a commission salesperson, the same way, their regular rate is going to be divided, their total compensation divided into the number of hours worked to get their regular rate. And that's going to be what is paid per hour of sick leave that's taken. Another curious one here is for servers. Lots of restaurant workers are affected by this. Recognize that an employer is still required to pay a server at least $7.25 per hour, but most restaurant hospitality employers take a tip credit of $5.12 per hour. So when we calculate their sick leave, though, they're not getting tips, so we have to pay them $7.25 per hour, and that is their real regular rate. So don't fall into the trap of thinking that it's just $2.13 per sick hour. And yeah, we'll be going back to that flow chart a couple times here as we move through. That's a pretty good tool. All right, so that is the paid sick leave for the reasons 1 through 3. Reasons 4 through 6, that if they're caring for an individual subject or advised to quarantine or isolation. Now, this is interesting here because the original bill said it's caring for a family member subject to or advised to quarantine or isolation. That was changed in the amended bill to say any individual. This seems to be really broad to me, that if it would seem to me that an employee is going to have an argument that they are delivering food to as part of a charity mission, as part of a church mission, as part of an individual do-gooder effort. I think that they would have a claim for sick leave if they're caring for the individual subject and for paid leave. And that brings up an interesting point that we'll talk about more in a little bit. The details of this are sketchy. We don't know the answers right now to how we prove or how we verify or how we question whether a particular illness is COVID related. We just don't have that. We don't have that information from Congress. We don't have the information from the Department of Labor. And quite honestly, I don't know that it's coming. If you've worked with us before, you know that we get pretty down to the nitty gritty pretty fast. And I'm going to tell you that the costs involved in complying with this and paying the person the sick leave that's requested is going to be a hell of a lot cheaper than trying to clean up the mess and rebutting a claim later on, right? As you've heard me say, 5% of your employees cause 95% of the problems. And if you've got a 5%er who's trying to take advantage of this situation and get up to $511 per day and bilk you out of $5,100 over 2 weeks, that's tough stuff. Another thing I've said is that all of this mess is going to really bring into pretty clear focus your hiring practices for now. You're going to see how well you've hired, what the ownership mentality is, whether your folks are pulling in the right direction, and who might be taking advantage of a bad situation. This is an employee-friendly law, as you'll see, and as you understand, it is not designed for employers' convenience. It's a mess. And so I would say lean into the law, do what it's telling you to do, adhere to the spirit, and then wait for that 5%er at some point to mess up on some other sort of at-will terms where their performance is a question and makes it a termination or a separation or discipline a little bit easier. Don't do it here. This number 5 here becomes important later on. The employee is caring for a son or daughter whose school or place of care is closed due to COVID-19 precautions. This is going to dovetail pretty well into FMLA, as well as one of the exceptions that we'll talk about. And then there's this catch-all down here that honestly we don't have much information about. We don't know exactly what is intended by an employee who is experiencing substantially similar conditions as specified by the Department of Health and Human Services in consultation with the Department of Labor or the Treasury. We simply don't know what that means. So if they are absent for one of these reasons, if they're taking advantage of sick leave for one of these reasons, employers are only obligated to pay 2/3 of their regular rate for these sorts of reasons. I don't know the difference between 4 and 6. As that question just came in, I'm trying to respond to these as we get through. And we'll have to take a lot of these individual questions offline. Simply can't get to all of them. We're already up against the time as it is. This is capped at $200 per day, $2,000 per employee for the time. All right, so in summary, the full-time employees are going to get 80 hours per week. Part-time employees, or those who work variably, are going to get the average number of hours they've worked over the past 6 months. The goal here is to give them 2 weeks worth of leave. So if you have a 20-hour-a-week part-time employee, they're going to get 40 hours of paid sick leave. Right? That seems to be the consensus of what they're trying to do here. The original law had 14 days. It's not going to work with the FMLA part. So if a part-time employee has not worked for 6 months, then it's the average number of hours they were expected to work. So the paid sick leave, if they are already out for something when this triggers, then it's going to become, and it's a qualifying instance, and it's going to trigger the paid sick leave. We'll get to what happens if they're already out on FMLA here in a minute. But I think you can see that this is burdensome, but it's not the end of the world, as it were. Especially might be as to relates to what may be coming down the pike. So the Department of Labor, Congress gave the Department of Labor the authority to exempt small businesses with 50 employees if it would jeopardize the business, but that only seems to apply to reason number 5. So going back to reason number 5, the only exemption that the Department of Labor can give for a business that is struggling and can't afford time off for somebody is this number 5. If it's 1 through 3, if it is one of the self-care reasons, then the Department of Labor cannot accept it. If it's reason 4 or this catch-all ambiguous number 6, the Department of Labor cannot accept it. I don't understand how that is going to work. I don't know how the Department of Labor is going to get these regulations out in the next 2 weeks before this starts to apply. Maybe we will, but until then, I think that you have to account whether or not you have 50 employees, whether or not you have 25, whether or not you have 450. You have to assume that this stuff is going to apply to you. The healthcare providers are also, and emergency responders are also generally exempted. So if you're a doctor's office, if you're a nurse, a nurse's organization, if you're a hospital, a smaller hospital, then you can exempt them from, you can exempt your healthcare providers and not provide them the pay to work, right? All right. This becomes effective 15 days after the president signed the bill, which was yesterday. So we're looking at April 2nd of 2020. It's supposed to have a sunset provision at the end of the year, and none of these paid sick leave benefits will carry over past the end of the year if they haven't used it. One of the most common questions we get is, what about the good employers who have already put in paid time off, paid sick leave policies? The law is clear that this sits on top of them, and you are not allowed to change your current policies. You are not allowed to change the policies, and if you already provided 5, 10, whatever the number of days off is, then this has to sit on top of that. You cannot reduce it from that. Creates a horrible, perverse incentive, but desperate times and desperate measures, I guess. Another interesting part of this is you cannot require an employee to use this over another type of paid leave or another type of paid leave over this. So it's another context we're able to decide how they're going to get paid time off. That doesn't necessarily apply here. Right? Employers are required to post notice of this new law as you communicate it to the employees. We don't know what that notice looks like yet. We anticipate the DOL will get that out sooner rather than later. And then employees must follow reasonable notice procedures. And your guess is as good as mine right now what that means. As I said, we don't have any mechanism right now to know whether or not they are going to, how we verify any of this. It's just completely up in the air, and we'll keep you posted as we do. I wish I had better answers. All right, so back to the flow chart. We've discussed, let's see if I can mark this up here. So we've discussed here the Emergency Paid Sick Leave Act, and now we're going to be moving down into the second part of this, which is the Paid Family Medical Leave Act. All right, so the Emergency Family Medical Leave Act, before we get started on this, I recognize we're going to be running up on time. I'll understand if people start dropping off. Obviously, this is a ton of material to cover, and we'll keep going as quickly as we can. So this just blows FMLA, the traditional FMLA, out of the water with respect to the coverage. So not only does it apply to every employee from employers with 1 to 499, so employers with 1 to 50 1 to 49 who used to be exempt are now covered by this. And then people who qualify for this emergency FMLA are going to get the next 10 weeks of their FMLA leave paid. This FMLA leave extension does not pay people who are already out on FMLA for other serious health conditions. It only applies to employees who have worked for 30 days prior to leave and have a qualifying need. In the original act, qualifying need was very broad and included a lot of the criteria from the Paid Sick Leave Act. As it turned out and what went into law, the only qualifying need has to do with an employee who is unable to work or telework because they have to care for a minor son or daughter due to the place of care being closed or a child care, the child care being unavailable. Once again, this is a lot of squishy words in what this means. We don't know what it means to be unable to work or telework because they need to care for it. It seems to me that there's some subjectivity here. I have a 15-year-old and a 11-year-old. I can work from home and telework just fine because they're largely self-sufficient. I could probably leave them at home and report to work. Is the mother or father of a set of 3-year-old triplets able to telework? I don't know. It seems to me that that's going to be a lot harder. Will they qualify under the FMLA for the paid leave? I don't have an answer for that right yet. How will we know if the child care provider is indeed unavailable due to a COVID diagnosis or issue, or the fact that they got flat tires? And does it matter? I think it does, but I'm going to tell you again that the cost of compliance here with these relatively narrow sets of ambiguity is going to be a fraction of the cost of defending these things later on. So again, our general advice is to give the leave, assume goodwill, and hopefully live to fight another day. These are employee-friendly laws that are subject to be taken advantage of, but under these circumstances, let's go ahead and lean in. All right. The first 10 days of that FMLA leave may be unpaid, right? So you cannot require them to use any paid leave, but you can allow them to take the paid sick leave. You can allow them to take their other PTO. Then after those first 10 days of leave, the employer must pay the full-time employees 2/3 of their regular rate for hours they would have worked. And for part-time employees, it's 2/3 of their regular rate in the same manner, calculated in the same manner as under the Emergency Paid Sick Leave Act. That is all capped at $200 per day. So you're looking at a total payout under this new FMLA at $10,000 per employee who takes that full 10 weeks. So the job protections are the same as FMLA leave, and the existing unpaid FMLA provisions remain in effect for non-COVID related leave, right? So FMLA keeps running its own course the same way that you have. It's only if it's a COVID related illness, and it's only for paid sick leave, and it's only if it's a COVID related qualifying need dealing with childcare does the FMLA turn into paid leave here. So I think that you start to see, while this is certainly not a great thing for your expense line, it's not as deadly as we might have anticipated. You're looking at a total maximum of $15,000 per employee who uses all of this leave. That's a big hit to take. I get it, but it shouldn't be crippling. Understand it's going to be tough. So hopefully that assuages some fears. Maybe not. All right. So the DOL has the same exemption authority. We don't know how that's going to play out. We don't know what the forms are going to look like quite yet. We're working on what we think they will, but we'll just have to see that play out. This caveat that's starred down at the bottom is the one that we cannot figure out, right? That employers with fewer than 50 employees in the 75-mile radius, which should be familiar for FMLA folks, are exempt from civil damages for emergency FMLA violations. Now, what this appears to me to say is that you cannot get sued if you don't comply with these new emergency family procedures. It essentially eviscerates the law, which that is such an amazing loophole that it seems to me to be a mistake. I mean, that's the exception that follows the rule, that swallows the rule. And I just don't see how that was intended to stay in there. Maybe I'm wrong. Maybe they are making this benefit gratuitous, and that small employers really don't have to comply. I'm going to tell you, go ahead and comply, because I would not want to make the very technical arguments that we'd have to in order to exempt off of this. And the biggest problem that you would have is the defense costs as you argue about this forever against what might be as much as a $15,000 outlay for your employee who takes advantage of it. That's more of the way that Stanton law practices, taking that practical approach. If you guys have a huge legal budget and want to argue over those things, more than happy to help you with that too. All right. So this also is effective on 4/20, sunsets on 12/31. There are no new notice requirements, but we don't know how that notice is going to be provided other than the standard forms, which don't really account for this, and then the foreseeable leave provisions. All right. So now you start to see hopefully how these two laws fit together, or how they were intended to. That the IPSLA is going to cover that first 10-day period, and then the Family Medical Leave Act kicks in to cover the next couple months, the next 10 weeks, putting the burden to maintain that employee's cash flow, at least to some extent, on the employer. So I think that now you can start to see how these charts really start to fit together, that we got to go through the emergency paid sick leave and its rather relatively liberal pay provisions and what qualifies for paid sick leave, the numbers 1 through 6, and then fall down to the Emergency Family Medical Leave Expansion Act with its broader expansion of FMLA, but then its very narrow qualifying leave. All right. Real quick, as you decide that this is not sustainable in your business anymore, and we have to take somewhat drastic action, remember that there's the WARN Act and its state analogs, that if you have to let go, if you're an employer with more than 100 employees, there might be reporting requirements. Nothing's going to prevent you from closing your business, but there's going to be arguments and notices that have to be made. Georgia, incidentally, just posted a new regulation yesterday that if you have more than 25 separations in a day or furloughs in a day, that you have to make specific requirements to the Georgia Department of Labor. We're going to talk a little bit about furloughs here in a minute, so hopefully we'll get to that before this thing clicks off. All right. So terminated employees can get are eligible for their normal unemployment insurance benefits. And when employees are fired, employers fill out a Georgia Department of Labor at Form 800, and the employee goes down and applies. If an employer decides to furlough, to reduce the hours from 0 to 1 hour per week from what they normally do, employees still may qualify for partial unemployment benefits. And if you do furlough, if you do reduce those hours, then it is the employer's responsibility to go on to this is for Georgia. Lots of different states are expanding these benefits. It's the employer's responsibility to fill out those claims for the employee. Lots more to say about that, but I want to get to probably for what you really came here. You want to know, can you fire people? The answer to the question is yes. Unfortunately, this is going to hurt for a little bit. If you have to get rid of people, you do have to get rid of them. We are not recommending by any means that you base your termination decisions on any protected characteristic, including those making decisions based upon who might be likely to use paid sick leave or the extended family leave. If we don't know how those causes of action are going to play out, but that's certainly going to be an issue when we come up. Can you furlough employees? Same thing, you bet. You can. It's been a debate in our circles about whether a furloughed employee is still going to be entitled to these benefits, and I believe that they will. That leads to the rather difficult decision of, do I say, folks, you can keep your job, but I can't pay you for right now. I need you to reduce your hours, and run the risk of them taking advantage of sick leave next. Or you go ahead and fire them, and then we may have some sort of interference claim because of their inability to use those benefits because they were just terminated right on the cusp of being able to use them. I don't have answers for that yet, unfortunately, but the answer to those questions is yes. I would recommend that we talk through the two scenarios. You do not have to pay for people not to work, except for the case in which a salaried, particularly salaried exempt employees do any work in a week. You have to pay them their full salary. And how much is this going to cost? Your guess is as good as mine, brother. It is going to be a nasty thing to watch go on. And I hope that we're able to help you withstand some of that coming. The individual cost to the per employee for these new laws probably will not be that great. I think it's capped at $15,000. And if that's what puts you under, it was probably going to happen anyway, unfortunately. But we'll see. We appreciate your indulgence on this. These are the attorneys who are going to be taking calls for these questions. There's other attorneys in the office, the associates, who will be looking to for particular support in other situations. But feel free to write down these names and addresses here and get in touch with us if we can help. As I mentioned, we've got a mechanism to allow non-Stanton Law clients to set up appointments to get quick answers. If you can please send an email to admin@stantonlawllc.com. That's admin, ADMIN, @stantonlawllc.com for details on how to schedule that call. We've arranged to do that 24/7 until this mess gets a little less messy. And of course, current S3LC clients can go through their normal attorney. We're also working on a compliance package on how to message this stuff to your employees. Until the DOL comes out with its appropriate forms, we're going to customize the other forms, and then we can also issue policy guidance as best we can to modify your existing FMLA policies or give you new FMLA policies if you haven't been subject to it before. So I've run 8 minutes over. I appreciate y'all's time. Stay tuned for the new updates, and I'm ending the call. We'll take this, one other thing. I'll take the questions that we've gotten. I've gotten probably a neighborhood of 200 questions during the panel. We'll try and address those in some of our future updates, and then hopefully have a call next week. The audio presentation is this audio and slide deck are being recorded. We'll get it up on LinkedIn, and we'll get it out on social media as quick as we can. Thanks, guys. Hang in there.
Thanks, everyone.